in your bookshelf with the rest of the volumes that you would take out and take into the courtroom with you and use when you were deciding whether your client should plead guilty or whether a sentence was appropriate or whether something would result in immigration law. I started practicing in 1977 and when I graduated from the University of Texas. And of course, like a lot of graduates in the 70s, I went out and tried to save the world, and I learned very quickly you don't save the world doing divorces, working for a legal aid and defender society. So after 10 months, I escaped that and gave up my efforts to try to save the world and told my parents I'll go back to Edinburgh if I don't make something of myself in Austin. And so I stayed in Austin back in the late 70s and early 80s when a foreign national was arrested and put into custody. A stamp was put on their booking card that said wet in red letters. So that's how you knew somebody was from another country. So being pretty much a go-getter, I would get up and go down and do court appointments then, and being the only Spanish speaker amongst the lawyers who were willing to be in court at 7 o'clock in the morning, I received all the criminal appointments for those people with wet stamped in their cards, and learned a little bit about immigration law because I looked around in Austin and I saw that there were about 5,000 lawyers and there was only one other lawyer doing immigration law. So not being totally, I think, out of it, I figured, immigration is something I need to learn. So immigration was a lot simpler then. The processes were a lot simpler for immigrating to the United States. There weren't as many business visas being allocated. There were more family-based immigration. I chafed, but not any longer, but I chafe when people ask me to recall a part of the law or a part of the history, of immigration law, because I've lived so much of it for the last 24 years that I've been in private practice. Immigration law is pretty incredible. I mean, there's regulations, there's law that you have to learn. You have to follow the Fifth Circuit Court of Appeals. You have to follow the Board of Immigration Appeals. At this juncture, I'd like to thank three people who pretty much motivated me. My mom, who taught me that I could learn anything, even something as complex as immigration. My dad, who right now is convalescing in a rehabilitation hospital in Edinburgh, who taught me not to quit, no matter how complicated something was. And an immigration lawyer in Edinburgh who was a pioneer in the field, Laurier MacDonald, who was pretty much my inspiration and taught me that all the answers were in the books, and when I couldn't find the answer in the book, I could make a case that would go into the book. So there's been a couple of things. I mean, I try in my paper to cover as many grounds as possible. I've tried to put into my paper every immigration-related case that has transpired since June of last year, trying to sort it out for you. I've got a good friend who is a worthy adversary in the Immigration Service, John Love, from San Antonio, and he has provided me with a chart that the Immigration Service uses in the state of Texas to determine whether somebody is an aggravated felon or whether a particular crime is a crime of violence, and that's in the back of the materials. And I think it's Appendix A. There's been some decisions in the last 4 months that I think have far-reaching impact for all of our clients, and I'm here not to talk just to the defenders, of the aliens, but the prosecutors, because we all participate in the criminal justice system together. And I would suggest to you that what we want to see is an outcome when you represent an alien or a foreign national, if you will, where the ends of society are met, the needs of the victim are met, the needs, if possible, of the defendant are also met. There's something particularly troubling here in the immigration law. It took place on May the 3rd of this year. And that was when the Fifth Circuit Court of Appeals in U.S. v. Hernandez-Avalos ruled that a felony, first offense, possession of a controlled substance, was an aggravated felony as a drug trafficking crime. So that means just about any individual who is convicted of possession of a controlled substance is now an aggravated felon. Now, the definition of aggravated felon is important because if you're defined as an aggravated felon and your conviction took place after October 8th of 1998, you're subject to mandatory detention. And you're subject to mandatory detention whether the Immigration Service takes you directly into custody from state custody or if they discover you several years later. Now, to give you an example of that, I hope I remember it because I haven't looked at my notes once yet because I know this stuff. I want you all to take this back with you. Somebody who immigrated in 1988 pursuant to the amnesty program, who had a deferred adjudication, which at that time was not a final conviction, who had a deferred adjudication for possession of a controlled substance, is now an aggravated felon. Okay, in 1996, the Immigration Reform and Immigration Responsibility Act eliminated Texas deferred adjudication from those criminal outcomes that were not considered final convictions. So in 1996, this gentleman who immigrated in 1988 became an aggravated felon because also the IRA, as it is called, was made applicable retroactively to any crime that was committed before, on, or after the date of enactment. Matter of Roldan, which was a Board of Immigration Appeals decision in 1999, held that no matter what the outcome of a criminal case, including the outcome at the conclusion of a period of probation or deferred adjudication where a court purported to set aside the finding of guilt and dismiss the indictment or information and dismiss all the charges, was irrelevant for purposes of IRA and left a person convicted regardless. Now, matter of Hernandez v. INS makes my 1988 alien who applied for amnesty, who made a full confession, okay, of his deferred adjudication, who was not deportable at that time, it was not excludable at that time because of a deferred adjudication, makes him deportable. Because the law has been upheld by the Fifth Circuit Court of Appeals in its retroactive application, you know, it applies to him, and it applies to him when he makes an entry. The first time he leaves the United States and comes back, he is making an entry. And at that entry, he would be subject to mandatory detention, though he would be eligible for a bond. Now, there is one ray of hope, and that is the Supreme Court, our Supreme Court, not the state, but the U.S. Supreme Court, which held that those pleas of guilty that were made under those circumstances where the alien felt that, or where the alien knew that it was not a final conviction, and it was not a final conviction for immigration purposes, would allow him to apply for what was called 212C relief, which is basically showing that you've lived in the United States for 7 years, been a person of good moral character during that entire period of time. But that applies only to people who were given deferred adjudication or probation prior to the effective date of the IRA, which was, I believe, October the 6th of 1996. Now, a couple of other things I'd like to point out to you. I know I only have 20 minutes, and this is going to be my only complaint. I could talk for 3 hours on this subject to criminal lawyers, and I talk all the time to criminal lawyers on the phone. There's a couple of things you need to know. There are some grounds there are some definitions of aggravated felon that require a sentence to 1 year or more to be considered as aggravated felons. So you need to, when you're looking at the chart and you're looking at in the book, I believe it's at page 11 in the materials, there's a listing of all the aggravated felonies. There are some aggravated felonies that require that you be sentenced to a year or more. So, for example, a person who is and one other thing, misdemeanors, state misdemeanors can be aggravated felons. And for example, let's take a Class A misdemeanor for theft, which I believe is sentenced to maximum sentence is a year, and somebody's given probation for 1 year to do, probated for 1 year. That is an aggravated felony. That is an aggravated felony. If it happens after the October, everything seems to happen in October, but October 8th, I believe, of 1998, that person is subject to mandatory detention. Now, if that individual charged with theft is given 11 months to do and it is probated for 11 months, it is still a crime involving moral turpitude for theft, but it is no longer an aggravated felony, and he would be entitled, or she would be entitled, to bail. Now, to illustrate another point, if that same individual is given 5 months to do, probated for 1 year, that offense is a petty offense. And the petty offense, I don't know exactly where in the materials it's mentioned, but is the petty offense exception to deportability for crimes involving moral turpitude. And that is for any offense where the maximum sentences can be no more than a year, and the actual sentence is no more than 6 months. Now, if that individual is given a deferred adjudication, he is still convicted of a crime involving moral turpitude. Okay, but he would qualify under the petty offense exception because under deferred adjudication, no sentence is actually imposed. So this applies to at least theft, crimes of violence, and burglary. Now, when I'm talking about burglary, there's two kinds of burglary for the Board of Immigration Appeals, and there's burglary of a habitation, which is an aggravated felony, and then there's burglary of a vehicle, which is not an aggravated felony, but it is still a crime involving moral turpitude.